You have people now, so it was perfect timing.
See right here. You want to
All right, the 14B District Court is back in session. The court will call the cases of the state of Michigan versus Samuel Dobrowolski, case number 21F00190.
One moment, Your Honor. I think he stepped to the restroom as well.
Okay. (21F00190).
Wait to me, Deputy, for the people.
Assistant Public Defender Sandra White, Mr. Dobrowolski has told me that he wishes to represent himself.
I'll wait till he gets back and we put all that on the record.
Okay.
Mr. Dobrowolski, please have a seat over here by the public defender, please. Before you sit, please stand and tell me your name.
Sam Joseph Dobrowolski.
Thank you, sir. You may be seated. All right, Mr. Dobrowolski, Ms. White indicates to me that you intend to represent yourself.
Yes.
All right, I have to give you some understanding before you can do that. First of all, sir, you understand that when you represent yourself, you're held to the same standards as an attorney. Do you understand that part? I need you to answer out loud, sir.
Yes, I do. I'll do my best.
Well, that's why you get an attorney, so you don't have to do your best.
She would not be able to speak the things I want to speak.
And maybe they shouldn't be spoken. That might be why. In this particular case, sir, you're charged with stalking. That is a misdemeanor. It carries a maximum penalty of up to 1 year in the Washtenaw County Jail and up to $1,000 fine and up to 5 years of probation. Do you understand, sir?
Yes.
This is a very serious charge. It is the court's advice that you accept the public defender as your representation, but if you choose to not do so, I have to make sure you fully understand that the consequences could be up to 1 year in the Washtenaw County Jail. Understand that, sir?
Yes, I understand.
All right. And in addition to that, I've already advised you that you will be held to the same standards as an attorney in this case. There will be no leeway simply because you're choosing to represent yourself. Do you understand that?
Yes.
All right. And in addition to that, this is a pretrial that was scheduled for today's date. Do you understand what that means?
Yes, and I heard that it was not scheduled for today. I assumed I was going to be turned away. I don't understand how there was a mix-up on the date.
Well, regardless of that, you're here. It's being held. All right. So Do you understand that today is the day and time scheduled for a pretrial in this case?
Yes.
Having said all that and understanding of the possible consequences to you, sir, do you still wish to represent yourself?
Yes.
All right. I'm going to appoint the PD as a standby only. So that means that you're representing yourself. They will only jump in if it looks like you're doing something completely ridiculous that would hurt yourself. Is there anything from the prosecutor as to this matter?
Your Honor, I'm not giving any legal advice, obviously, but given that Mr. I don't want to pronounce his name incorrectly, Dobrowski, sorry about that, has just said on a few different occasions that he doesn't understand how this works. He's absolutely correct. I believe discovery needs to still be turned over to him and reviewed. And I am more than happy to engage in negotiations to resolve a case. But I don't know that we will, I'm going to request an adjournment on behalf of the people. Let me put it like that, so that I can ensure that I've had an opportunity to fully discuss what needs to happen going forward if there's going to be some sort of resolution, or if he decides to reject offers in trial. So I'm going to request the people's.
All right. Sir, I've just been told that you don't have discovery in this case yet. Do you even know what that means?
I was having trouble understanding what you were saying because of the technology.
It sounds very clear to everyone else in this room. So, sir, there will be no game plan. I'm not up for it. Do you understand?
I'm just, I don't know what's going on. I don't understand what you were saying about what if the discovery. I don't understand that. Oh, I understand what they are, and I remember everything. I got nothing to hide, and I have certain things I want to say. And wasn't that giving them extra time to? I just want to get this done right here.
Mr. Dobrowski, let me explain something to you. There's a process to this procedure. Whether you represent yourself or not, that process is still going to happen. At pre-trials is not an opportunity for you to have a full discussion with the court about anything. That's not how this works. So whether you have an attorney or not, it's not going to change that. You will not be allowed to do that either. Am I clear?
Yes.
If you don't follow the court's rules, then what happens next is you can be held in contempt of court. Contempt means that you do jail time for being in contempt, and then you still have to deal with your case. Do you understand that?
Yeah, I'm okay with all the proceedings, the adjournment, the discovery. I'm okay with that.
And Your Honor, I know that since this is being made on my request, I'm also going to advise the court that based on what I'm looking at in this file, including previous orders and petitions, that I may need to make a request for a referral on behalf of the people as well, but I need to look further into it. So I would ask if we could have the adjournment right now doesn't need to be long, but just a heads up that another request may be forthcoming.
Do you think 2 weeks would be enough? It's either going to be June 6th or June 20th.
I will know for sure. Yes, Your Honor, I'll know for sure about whether I need to send in and request for an order after that.
My question was, will June 6th work or June 20th, Madam Prosecutor?
Oh, I'm sorry, Your Honor. I missed that part. June 6th is fine.
June 6th, 2024 at 11 a.m. in person again, sir. But at any point in time, sir, you decide that you've gone down the wrong path by not having an attorney, you can request and we will reappoint the PD's office for you. It is not wise for you to go this path you're going in, but those are your choices. Do you understand, sir?
Yes.
All right, we'll see you here on June 6th. If you wait 1 moment, we'll give you a notice.
May I ask, if standby counsel can just communicate, to me regarding, I don't have obviously his, direct information, so I just want to ensure that I have what I need to get in touch with him before the next day. So if Ms. White could just reach out.
I think what she's asking, if you could get his contact information and give that to her. Sir, just so you are clear, all of the original bond conditions in this case still stand. Those bond conditions, so I can reiterate them, are for you to have no contact, no go-to, no weapons. You have no contact in this case with Catherine and Stephen Williams, no go to the Glenwood address. Do you understand that?
Yes, I do.
Is there a testing order on this file?
No use of alcohol, marijuana, or illegal drugs. There does not appear to be a testing order. Is there an allegation that there was substance use in this particular case?
The allegation in this case is that, there are substances that have been used in high doses, which cause, which is suspected to be behind some of the behavior in this case, yes.
Alright. What are the substances?
I'm sorry, I just gotta scroll back up. Dextromethorphan, which I don't know what that even is right now. Let me see if I can look that up.
Are we able to test for that?
Let's see. That's just cough syrup. So I think it's the allegation is abusive. Over the counter,
I don't think we can test for that. So,
but a baseline might be good. Just generally for everything.
sir, well, you're not represented. So, sir, are you gonna test positive if you are tested in the next 24 hours for anything?
No. No.
Okay. Defendant to test within 24 hours. At community corrections. If you are negative, then no further tests. If you're positive, then you will be on a testing order of 3 times per month, okay? Please go to community corrections and test within 24 hours, sir. Thank you. State of Michigan versus Reuben Bottoms, case number 21S00173.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Reuben Bottom. You take me correct?
Good afternoon, Your Honor, Reuben Bottom.
Good afternoon, Mr. Biden. Mr. Biden, we've been doing this a while.
Yes, ma'am.
So last time you were here on April 11th, you pled to failing to sign your probation contract, failing to drug test as ordered, failing to complete the community service, failing to complete the math victim impact, and failing to report to probation for over 1 year. I adjourned your sentencing today to today's date to give you an opportunity to show me that you were gonna do what you were supposed to do. Have you had an opportunity to review the report with your client?
I have, Your Honor.
All right, what would you like to say? And I have a new violation. At this time, I'm gonna arraign you on the new violation. Did you go over that with him?
No, Your Honor. What's the new violation?
You failed a drug and alcohol test as ordered.
Yes, we've talked about that.
Okay, so sir, at this point in time, I'm arraigning you on the violation that was filed on May 22nd, indicating that since the time that I gave you a chance to show me you were gonna do what you're supposed to do, that you failed to drug test as ordered. In fact, It says that you have missed tests. Since March 20th to 24, you missed tests March 25th, April 16th, April 18th, and May 1st. If it is found that you're in violation of your probation, then you can be subjected to the original maximum penalties in this case, which is 93 days in the Washtenaw County Jail. You have credit for 9 days that have been served. The recommendation at this time is for, in fact, that entire time. What would your client like to do?
He would like to admit the violation.
Sir, please stand and raise your right hand. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Sir, is it my understanding that you're gonna plead to the allegation of failing to drug test this and alcohol test this order, then you missed all the days that I just indicated to you?
Yes, ma'am.
Okay, and my understanding is you also missed yesterday.
Yes, ma'am.
All right. I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, ma'am.
Ms. White?
Satisfied.
All right. What would you like to say on behalf of your client?
Yes, Your Honor. I'm sorry. Lost my notes. Mr. Bottom just would like the court to know that he does apologize for everything. He just has not had the money to test. And that is his reason for missing the test. He has tried everything to get the money. In fact, he had to donate plasma just to get here today. He did complete the MAD Victims Impact Panel. He has done some of the 12, he has completed some of his 12-step meetings. He takes care of his children, which is some of the reasons why he hasn't completed a community service between not having transportation and trying to get things adjusted with his wife. He does have a job interview today, so he's very hopeful that he will now be able to complete some of the things that have been ordered for him. This has been a more positive year for him. I know that doesn't seem that way, but this is an older matter. He has started to complete some things. So I believe at the last court date, Your Honor, ordered him to complete something. He did complete the MAD Victims Impact Panel. I did explain to him that it didn't mean to stop testing. But again, he said that he just didn't have the money, and he has tried everything to borrow money and get money. But again, he had to just donate plasma just to get here today. He wants another opportunity. He knows he's had several opportunities. But now that he's on a more positive track and is able to, although slowly, get some things completed, now that he is looking at a second interview, he should be able to have the money to be able to test and get more things done.
Ms. McDuffie?
Mr. Bottom has had a recommendation for jail for the violations on this case since at least January 4th. And he said a lot of words to us at his last hearing about how he apologized and there wasn't really an excuse. And honestly, I was concerned, and I think we all were, that based on what he was reporting about the MAD, which he has now completed, that he just was having some sort of issue comprehending, maybe some sort of learning disability, because of the way that he described the trouble he was having passing the, quizzes and everything at the end. But this has nothing to do with that. This is just testing. He knows what testing is. He doesn't do it. He missed 19 tests back in 2022, and that problem continues today. I don't know why Mr. Bottom is expecting to go to a job interview today, because Mr. Bottom should have come to court expecting to go to jail. And I don't say that flippantly at all. He was given one last chance, one last chance the last time, because at least he had been in touch with his agent and explained the trouble he was having completing those requirements. Today was completely it. It was the absolute last straw. So I appreciate that he's having difficulties, but he hasn't even been in contact, it looks like, since the last time. Not that that would have excused what he hasn't done. I don't know what the problem is. I truly don't. But I don't know that the court has any reason to look to the situation with hope for the future, that it's all magically going to turn around and get better once he gets more money. Because money is maybe just one factor here. Something's wrong with Mr. Bottom's ability to understand, comprehend, and follow through. And I don't know what it's gonna take to change that, but it hasn't changed today, and he's been given a bunch of chances to do it.
Mr. Bottoms, your opportunity to speak, sir.
Yes, ma'am. I understand the situation. This is like really, like, I know we've been through this more than once. Like I've told, my public defender, I know for a long while I was not taking care of none of this at all. And then that put me in the position I'm in today. And like I told her, I feel like this year, I mean, I know I've completed more of my probation than I have in the past and even gave it an effort to. And the main reason for the testing was my mom with the money was one thing. And I started watching my kids because my mom got sick and she was watching my 3-year-old and then my other two when they got out of school. So I've been watching them. I've been an at-home dad watching them and taking care of the house with my girlfriend. She's been working. We've had a little conversation trying to figure stuff out. And being that it's the end of the school year, my kids will be out of school next week. And their older 16-year-old brother will be out as well. He will be able to free up my time during the day to do the community service and pay the rest of the fines and fees. And as far as the drug testing, I know I haven't been going, but I was wondering if it was possible, instead of having a GPS tether or alcohol tether to show and prove to the courts that I haven't been drinking, even without doing the drug testing.
That was an option for you to ask for last time you were here. We're beyond that at this point, Mr. Bottom.
Yes, ma'am.
You also did not provide proof of any of the 12-step meetings that you were supposed to be doing.
I brought the paper last time, and I thought that, I mean, I gave it to the courts. It had like 4 or 5 days on there that I went to meetings.
That's not all you.
Your Honor, if I could ask a question.
You may.
Do you have record that you approved Mr. Bottom to use medical marijuana?
Let me check.
I don't see it on my end of things, but I just wanted to double check. I don't know if Mr. Bottom actually has a medical card or if he previously used recreationally.
I
The
don't-
last time he was testing, it was positive for THC.
I don't see any approval for that. I told Mr. Bottom as far back as March 10th of 2022 that if he missed any further tests, he was going to do jail time. So, anything further today, Mr. Bottom?
I mean, you know, nobody wants to go to jail. I understand the situation I'm in. I've been doing my best with the probation. I don't know, man.
Thank you.
Yeah.
I do understand that sometimes people don't have the funds to be able to test like they're supposed to. But the fact of the matter in this case is you knew this was your last opportunity. Maybe you just haven't taken me seriously since I've been telling you for 2 years that I was gonna do this. What would you like to say, sir?
It's been in 2022, I was absent for 1.5 years. And then me just coming back around this time is when you started getting on me and telling me to do things and take care of things. And like,
I think Mr. Bottom is trying to say, and I know we tried.
no, oh, I'm sorry. I didn't mean getting on me like in any disrespect.
Okay, go ahead, I'm sorry.
I'm sorry. Is that what I meant like you've been more persistent of me telling me to make sure I do these things and tell me to do them. And so like, I wouldn't say from 22 that.
I wrote my own note here
Yes,
to
ma'am.
myself. at the time of sentencing where I told you on March 10th of 2022, you're going to do jail if you miss any more tests. And instead of that, you just disappear. You're right. You did. You didn't do anything I told you to do. You simply disappeared. But instead of me giving you jail time, you came back with your story and I gave you an additional time. Then you came back again and I gave you additional time. We're done. This is it. I'm not gonna give you the full time because I know that sometimes people can't afford to do what they're supposed to be doing. But you haven't been doing anything lately. You haven't been doing any of the tests. Like you can't come up with $12 one time. You couldn't even do that? No? Okay. 30 days in a Washington County jail, credit for 9 days, your probation is revoked. You can do the Don Farman jail program if you see fit.
Myself, this is Mike.
State of Michigan versus DeAndre Jordan, case number 22S00527.
Victim and deputy for the people.
Yes, fines and costs are waived in that last case.
Assistant Public Defender Sandra White on behalf of DeAndre Jordan, can you state your name for them?
All right, we gotta wait for the bailiff to return. You can have a seat, sir. While we wait for the bailiff to come out, Mr. Jordan also has a new violation that I need to arraign him on. This is from May 22nd, 2024. It is alleged that Mr. Jordan, you failed the drug test as ordered also. Failed the drug test on February 29th, March 4th, March 13th, April 3rd, April 30th, May 9th, May 14th. Do you understand those allegations, sir?
Yes.
All right. You have a right to have a hearing on those allegations, at which time, if it is shown that you violated the terms of your probation, you could be subjected to the original maximum penalty. In this particular case, it is recommended that you do 93 days in the Washington County Jail, credit for 1 day, sir.
I'm so sorry to interrupt, Your Honor, but we also have 4 scram tamper events since this last hearing.
What?
That was attached, yep.
On what's called a progress report?
I don't know why it's called that, but yeah.
Your Honor, that progress report, I think, is mislabeled. The violation report was sent before that progress report. I just wanted to give you the most updated one that included since the violation. He was already arraigned on those tether violations by the magistrate, I believe.
Let's see here. I don't think that's, no, I don't. No, the last arraignment by the magistrate was February 14th.
I had court like April.
That was with me.
After that.
That may be true. I'm not denying that part, sir. What I am doing right now is arraigning you on the fact that on March, they allege that on April 13th at 12:28 p.m., there was a deviation in the actual scram tether, which would confirm, and that a tether tamper was confirmed for 13 hours and 8 minutes on April the 14th. Then there was another tether tamper on April the 15th for 16 hours and 42 minutes. And then another tamper on April 20th for 15 hours and 9 minutes. And then alcohol was detected on April the 25th during a scram tether tamper for 9 hours and 9 minutes. So you're entitled to have a hearing on that as well, at which time, if it is found that you violated, the same penalties apply. So you have tamper violations and failing to text violations. And I think what Mr. Jordan is trying to say is that he was here on April the 11th, and at that time he wasn't arraigned on these, but at that time I was not aware of them because they didn't send it over until May 21st.
Well, they didn't exist yet because the first one is April 13th, right?
Yes, that's correct.
That's my fault, Your Honor. I'm sorry. He had not been arraigned by the magistrate. I misspoke.
So Mr. Jordan, you were here before me on March 7th, at which time you pled to the violation in this case for failing to drug and alcohol test as ordered, failing to complete the victim impact panel, failing to complete the CCEOP assessment, failing to report for over 6 months. I adjourn for you to show me that you were going to do what you're supposed to do. In the interim time period, I've got these failing to test and scram tether violations. What would your client like to do?
You like to admit to the failing to test, Your Honor. As for the scram tether violations, we just got a report this morning from Mr. Casey as to the scram violations. So we would like to adjourn to go over that with Mr. Jordan.
Can I say something?
That's up to your attorney.
Want to know about the CPO for that. I don't know what to do about this. Right, I haven't had alcohol. Not had alcohol. Might have to. Is it?
So are you're requesting the adjournment? Is that your request? You were talking to your client. I don't want to interrupt.
Yes, as far as the scram tether, we are requesting an adjournment. We just got the report from Ms. Mueller requested the scram tether report, and we just got it this morning.
Ms. McDuffie?
I don't have any objection to the adjournment, so that, and it is my hope that Ms. White will fully advise Mr. Jordan on what a hearing for this sort of offense or allegation looks like, and whether or not she advises him to try to pursue one. I do need to request the report from JSG so that she can have that information as well to probably facilitate that conversation. So I should be able to get that by the end of the week.
June 27th, 2024, at 11 a.m. in person, sir. I'm not gonna bifurcate these. We're gonna take one plea or have a full hearing. Go from there. You and your client can talk about what you want to do.
Yes, sir.
I'm gonna give him a personal recognizance bond. He has shown up here today. Are you doing the CCOP, sir, like you were ordered?
Also attended Little House.
I'm sorry, what, sir?
Also attended the 12-step program.
At the Little House? Okay.
Right after COP.
I can tell you this, sir, you should not have any more scram tether violations between now and your next court date, or I'll issue an immediate bench warrant. Do you understand?
How do I avoid it? Because I'm not drinking. I swear that I promise I won't even
Don't.
disrespect you like this.
It'll be scheduled for a VOP hearing and the sentencing.
Yeah, sure.
You know, people always say things to me like, how do I avoid having these type of incidences? And we have tons of people who are on, they don't have incidences. They have incidences when they're doing things that have incidences, so. All right. We'll hear from you on your side when you get back. You're all set. She'll give you your notice, okay?
Your Honor, is it possible for Mr. Jordan, if you want to test,
Yes, please.
if his testing could be moved to Detroit, or should he talk to the probation officer about that?
No, it can be moved to Detroit. I mean, we don't want to inconvenience him and have to come all the way here if he lives in Detroit.
Or on that Monday, I can, every time I go to that class.
The class is a different story, though. I don't know if that's, and we're not gonna do testing on any day that you think,
Okay.
you know what's happening. We do testing when you're surprised. That's the goal, okay? But we can move it to Detroit, okay?
Your
All
Honor,
right, yes.
he would also still have to report for his weekly scram downloads to community corrections. So he would still have to go at least weekly over there. That can't be transferred.
I can do that Monday for the CO.
Oh, on the Mondays when you
That's what
come
I've
for
been
that
doing,
class.
yes.
Okay, yeah, he's got that under control, it sounds like. He just does it when he comes from CCOP. Okay, all right. Thank you, sir. Thank you, ma'am. State of Michigan versus Ryan Webb, case number 20-00255.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Ryan Webb.
Ryan Webb.
Good morning, Mr. Webb. So, Mr. Webb, I'm gonna arraign you on your new violation as well. It alleges that you tested positive for cocaine on May 20th, 2024 in violation of the no use or possession of illegal drugs portion of your probation. Sir, you're entitled to have a hearing on this, at which time if it is found that you violated or you admit to violating, you could be subjected to up to 10 days in the Washington County Jail. That is what is being recommended at this time. Do you know what your client would like to do?
He would like to admit to that violation, Your Honor.
So please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Sir, is it true you tested positive
Yes.
on May 20th? I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Ms. White?
Satisfied, Your Honor.
Thank you. Mr. Webb? Your problem is different. You have a problem. You got an issue you got to address. Are you willing to acknowledge that yet?
Yes, ma'am.
You did time right up front in the beginning, didn't you? Can you take us off?